How do you analyze a negligence issue on a tort essay question? Well, your entire analysis is going to be centered around the following 4 elements. To hold a defendant liable for negligence, the plaintiff must establish the following 4 elements by a preponderance of the evidence. Number 1, that the defendant owed a duty to the plaintiff to conform to a specific standard of care, that the defendant breached that duty, that the breach was the actual and proximate cause of the plaintiff's harm, and that the plaintiff sustained actual damages or loss. In short, you will often hear these 4 elements referred to as duty, breach, causation, and damages. And this is going to be the heart of your negligence analysis. On a tort essay, you're going to have to run through all 4 of these. And each of these elements is going to present unique issues that you're going to have to address. So in this video, we're only going to focus on the first element, which is duty. And what's interesting about duty is it's really a 2-part analysis. First, you're going to have to establish whether the defendant owed the plaintiff a duty. And second, you're going to have to determine what that duty is. What is the level of care that the defendant owed the plaintiff? We refer to this as the standard of care. And this is going to be the second half of your duty analysis. But we don't even want to focus on this in this video. All we want to discover right now, all we want to think about is whether the defendant owed the plaintiff a duty of care. We don't care right now what that level of care actually is, what the standard of care is that's going to be applied. We just want to try to figure out whether a duty was owed. Very straightforward. Okay, so if you bear with me for 1 second, I'm going to write these elements at the top of this board because it's important to remember them as we go through this duty analysis. So remember, the 4 elements, the flow of your analysis is going to be duty, breach, causation, and damages. These are your 4 elements of negligence. But remember, right now, we're just focusing on duty, specifically how you determine whether the defendant owed the plaintiff a duty to conform to a specific standard of care. Remember, we're not going to worry about the standard of care part. We're just focusing on whether the defendant owed the plaintiff a duty of care of some kind. So what is the best way to discuss duty? I know some of you are going to cringe at this, but I'm going to go back to a case I know you all remember, know, and love, Palsgraf v. Long Island Railroad. This is going to illustrate duty, how you determine whether a duty is owed, beautifully. Okay, so if you don't remember the fact pattern of Palsgraf v. Long Island Railroad, I'm going to try to quickly refresh your memory and excuse this drawing I'm about to put on the board. I promise you this will be the worst display of artwork you've ever seen. But remember, we have a railroad. A rail track is what I'm drawing right here. And at this railroad station, we have a moving train, right? Here's my moving train, right? There's probably some sort of wheels at the bottom of a train. I'm not even sure. Is it wheels? Yes, I'm sure it's wheels at the bottom of the train. So here's my moving train, right? And so what happens? You have a guy, a passenger, who's trying to board this moving train. So let's draw him in. We got a passenger who's trying to get onto the moving train. And he is holding a briefcase, right? I'm sure many of you remember this. And so what we have are railroad employees trying to help this guy get onto the moving train. So they're kind of pushing him, trying to get this passenger onto the moving train. So he's trying to get onto this moving train. And remember, we have this lady all the way on the other side of the tracks, Miss Palsgraf. She's way down here, just chilling, minding her own business. Okay, and what happens? As these railroad employees are pushing the passenger onto the plane, this briefcase gets dislodged and dropped somehow. And what's in the briefcase? Unbeknownst to the railroad employees, there is fireworks in the briefcase of all crazy things, right? And the fireworks become dislodged, somehow ignite and explode. So we have this big explosion as this passenger is trying to get onto the moving train. So I'm just gonna write pow, right? Big explosion, which sends a shock wave all the way rippling down the tracks, right? And all the way at the other end, a piece of equipment is dislodged and hits Miss Palsgraf. And now she is injured. So to recover, ouch, right? To recover her damages from this injury, she wants to sue Long Island Railroad for negligence. And our question we want to focus on in this video is whether Long Island Railroad owed Miss Palsgraf a duty of care. What that duty of care is, we're not focusing on. All we want to ask is, did Long Island Railroad owe Miss Palsgraf a duty? You all remember this case is called Palsgraf v. Long Island Railroad. And it's probably the most seminal case you'll ever study in torts for sure, right? So how did the court determine whether the railroad company owed Miss Palsgraf a duty? Remember, that's your first element of negligence. So you have to establish, if you're the plaintiff, that the railroad owed you a duty of care. Well, we have two opinions here, right? We have Cardozo and the majority. So we have Cardozo with the majority opinion, and we have Injures with the dissent, or the minority opinion. Okay, and I know oftentimes students only focus on the majority. This is one of those times where you really do want to focus on both the majority and minority opinion to really rack up all the points you need on a tort essay question. You're going to have to discuss both of these approaches in your duty analysis. So what does Cardozo actually find here? Does he find that Long Island Railroad owes Miss Palsgraf a duty of care? He says no. He says that it was when the railroad employees were pushing this passenger onto the train, there is no way that they could have foreseen that that briefcase was going to have fireworks in it, that those fireworks would somehow become ignited, explode, send a shock wave down the tracks, dislodge a piece of equipment, and hit Miss Palsgraf. They're saying the railroad employees could have never foreseen that as they were pushing this guy on the train. He coins this term as the zone of foreseeable danger. He says Miss Palsgraf was outside the zone of foreseeable danger, so no duty was owed. The zone of foreseeable danger I like to think about as a bubble, right? You can imagine as you're walking around outside in the streets, driving your car, you constantly have this bubble or force field around you. That's kind of your zone of foreseeable danger. And you're only owing duty to those around you that are within that bubble, within that box, within that force field, this invisible zone of foreseeable danger. Anybody outside of that zone, you don't owe a duty, right? That is what Cardozo is saying in Palsgraf. Andrews comes along and says, if the defendant can foresee harm to anyone as a result of his negligence, then a duty is owed to every person harmed as a proximate cause of his breach. What he's basically saying is, let's forget this whole zone of foreseeable danger thing. Let's get this idea of a limited bubble or force field out. And let's just say that basically you owe a duty of care to society at large. You should be taking steps every day to take reasonable precautions and behave reasonably to everyone, not just people within this zone of foreseeable danger. So how does he reconcile, though, the fact that we still have this crazy fact pattern, right? How does he reconcile that Miss Palsgraf is clearly an unforeseeable victim? I mean, how were these railroad employees supposed to know that there were fireworks in this briefcase and that was going to cause this crazy chain of events that was going to injure Miss Palsgraf? Well, he doesn't forget about that issue. He just moves it in the analysis. He says, that's not a duty issue, that's a causation issue. That goes to proximate cause. And I know we haven't studied proximate cause yet. I'll make a video that outlines proximate cause in a lot of detail. All you need to know right now is proximate cause basically says, if an unforeseeable event happens, it can break the chain of liability. So the defendant is liable up until the chain of liability is broken. And the way under proximate cause that chain of liability is broken is when an unforeseeable event happens, like, I don't know, something like a briefcase full of fireworks that no one could have known about explodes. So what he's saying, what Andrews is saying, and what most legal scholars kind of agree with is, look, let's not worry about this as a duty issue. Let's just cover this idea of the foreseeability of the victim under causation when we discuss proximate cause. So the irony of this case is both of these justices probably would have came to the same result. They just take different methods to get there. Cardozo is saying, let's talk about the zone of foreseeable danger. Justice Andrews is saying, forget the zone of foreseeable danger. Let's just say if the defendant can foresee harm to anyone as a result of his negligence, then a duty is owed to every person harmed as a proximate cause of his breach. So basically what Andrews is saying, if you want to break down the duty analysis from the Andrews opinion, is that the defendant, Long Island Railroad, could foresee harm to the passenger that they were pushing onto the train, or maybe passengers on the train, right? The action of pushing a guy onto a moving train, you could foresee harm happening to someone. Whether it's the guy you're pushing, whether it's people on the train, that's clearly got some level of negligence in it. Now, maybe you didn't know that there were fireworks in the briefcase, but that doesn't matter. You could have foreseen some harm to someone. Therefore, you owe a duty to everyone that is harmed as a proximate cause of your breach. So everyone who was a proximate cause that was harmed, a duty would have been owed. But Miss Palsgraf at the other end, is that a proximate cause of that breach? That's the question. And that's what Andrews is saying. And that falls under your causation analysis. So again, he could have come to the same result, but he's saying it's a causation issue, not a duty issue. So save the analysis of the foreseeability of the victim for our third element, causation, not duty. I hope all of that makes sense. But that on a tort essay is how you're going to break down a duty analysis. When you're trying to determine whether a duty was owed by the defendant to the plaintiff, think about Palsgraf v. Long Island Railroad. You're going to want to run through both of these analyses, right? You're going to apply both approaches. You're going to cite Palsgraf, you're going to cite the Cardozo opinion and the Andrews approach, right? The Cardozo approach being the zone of foreseeable danger, and the Andrews approach being the idea that this foreseeability of the victim falls under causation. And you want to run through your analysis under both approaches to get maximum points on a tort essay. Now remember, the result should be pretty much the same. It's the same idea, you're just switching where it is in your analysis. There's a classic example probably of one of the times where the law over-convolutes something, right? You're coming to the same result, but it's a convoluted approach, but you want to make sure that you do it, that you do follow this, you do discuss both approaches. That's what any grader of a tort essay is going to want to see. But with that, guys, I'll leave you to it. I hope that makes sense. In our next video, once you establish that a duty was owed, you're then going to have to establish what that level of care owed was. We call that the standard of care. We'll discuss that in our next video. But until then, guys, I wish you all the absolute best, and I'll see you at our next video.